In the U.S. Court of International Trade dealt another blow to President Trump's trade policy. The panel of 3 federal judges ruled that President Trump's 10% across-the-board sweeping tariffs are illegal. He imposed the tariffs after the Supreme Court struck down his most sweeping levies earlier this year. The latest ruling now comes after 24 states, including Washington, and a group of business leaders challenged the tariff. The court is ordering the administration to stop collecting the tariffs and refund prior payments. The president said he was not surprised by the ruling.
Nothing surprises me with the courts. Nothing surprises me. So we always do it a different way. We get one ruling and we do it a different way.
The Trump administration is expected to appeal this latest decision.
Listen up, folks. Adam speaking "this just changed everything." Supreme Court justices are publicly fighting back, unusual for an institution that typically lets opinions speak for themselves. In speeches and interviews, they are using unmistakable language directed at Trump's pattern of attacks on the judiciary. 3 Supreme Court justices, Roberts, Gorsuch, Trump appointed, and Jackson, have publicly warned that attacks on the judiciary are dangerous and appear intended to intimidate the court. Their unusual public pushback signals a rare, unified institutional defense. This is an extraordinary moment in American constitutional history. And we are going to walk through every piece of it right now. Because understanding what is happening between this president and this Supreme Court is essential to understanding where this country is heading. The relationship between the executive branch and the judiciary is one of the foundational pillars of American democracy. And that relationship is currently under more strain than at almost any point in modern American history.
We begin with the decision with major implications for the economy and your money. The Supreme Court dealing with a major blow to President Trump's economic policy, striking down his sweeping use of tariffs.
It was a 6-3 ruling today, with 2 justices appointed by President Trump himself siding with the majority. The president railed against the decision today, calling it deeply disappointing and saying he was absolutely ashamed of the justices who voted against his policy.
And the president has already announced alternative plans to keep his tariff policy in place. But what about all the money that was already paid?
Well, CBS LA's Amy Johnson begins our team coverage tonight to break all that down for us. Amy?
Well, Pat and Juan, within the last half hour, President Trump posted on Truth Social that he just signed a global 10% tariff on all countries, effective almost immediately. It's a sign he's not backing down from his trade agenda, despite the court's decision.
The justices are speaking out. The president is attacking back. And the entire constitutional order is watching to see what happens next. Now, let us understand the context that produced these extraordinary judicial responses. Because the Supreme Court did not decide spontaneously to start pushing back against presidential attacks. The pushback came in response to a specific and sustained pattern of presidential behavior that escalated significantly after a major ruling that struck down Trump's sweeping global tariffs. The court ruled that Trump had exceeded his statutory authority and that the constitutional power to levy import duties belongs to Congress. That ruling was a massive policy defeat for the administration. And Trump's response was extraordinary in its fury and its institutional disrespect. He called the court completely inept and embarrassing. He called individual justices fools. He called them lapdogs. He said the justices who ruled against him were a disgrace to the nation. He claimed without any evidence that they had been influenced by foreign interests. He said he was ashamed of justices he himself had appointed.
The Supreme Court's ruling on tariffs is deeply disappointing, and I'm ashamed of certain members of the court, absolutely ashamed, for not having the courage to do what's right for our country. I'd like to thank and congratulate Justices Thomas, Alito, and Kavanaugh. Foreign countries that have been ripping us off for years are ecstatic. They're so happy. And they're dancing in the streets, but they won't be dancing for long, that I can assure you. To the contrary, the Supreme Court did not overrule tariffs. They merely overruled a particular use of IEEPA tariffs. And essentially, it's used to get a fee. I can do anything I want with IEEPA, anything. I just can't charge anybody for it. Therefore, effective immediately, all national security tariffs under Section 232 and existing Section 301 tariffs. They're existing, they're there.
And he publicly characterized the ruling as driven by disloyalty rather than by law. That pattern of response, calling justices fools and lapdogs and disgraceful and disloyal and accusing them of foreign influence, is what produced the unprecedented judicial pushback that we are covering today. Courts respond when the attacks cross from political disagreement into something that scholars and the justices themselves have identified as genuinely dangerous. And that line has clearly been crossed. The justices are no longer willing to remain silent while the president publicly attacks their integrity, their motives, and their independence. They are speaking out in ways that are historically unprecedented. And they are doing so because they believe the attacks threaten not just their personal safety, but the institutional integrity of the entire judicial branch.
The Supreme Court's ruling on tariffs is deeply disappointing.
President Trump sharply criticized the Supreme Court justices who struck down his sweeping tariff policy. That includes two justices he nominated during his first term, Gorsuch and Barrett.
I'm ashamed of certain members of the court, absolutely ashamed.
In a 6-3 decision, the High Court ruled the president does not have the authority to impose tariffs under a 1977 emergency powers law that he used to wage taxes on nearly all U.S. global trading partners.
This is all about the idea that the Constitution gives Congress the power to regulate commerce, that the Constitution gives Congress the power to impose taxes.
So let us start with Chief Justice John Roberts, because his response was both the most significant institutionally and the most carefully worded, which is exactly what you would expect from a Chief Justice who has spent his career thinking about how to protect the court's institutional standing while navigating a deeply polarized political environment. After Trump's outburst following the tariff ruling, Roberts gave a rare public speech in which he addressed the pattern of attacks on the judiciary directly. He did not mention Trump by name, which was itself a deliberate choice, maintaining the institutional posture of the Chief Justice, speaking about principles rather than engaging in political combat. But the target of his remarks was unmistakable to everyone who heard them. Roberts said that criticism of legal decisions is part of the job, that judges understand they will face criticism when they rule in ways that disappoint powerful people, that criticism of outcomes is both legitimate and expected. But then he drew a line. He said that personally directed hostility, attacks on individual judges by name, attacks that question their motives and their integrity and their loyalty is perilous. He said such attacks are dangerous. And he said they have got to stop. 3 short declarative sentences from the Chief Justice of the United States directed at the President of the United States about a pattern of behavior that the Chief Justice has concluded threatens the safety of judges and the institutional integrity of the court. That is remarkable. And the word dangerous is not rhetorical. It is a direct acknowledgement that personal attacks on named judges create environments in which those judges face real physical threats. Roberts does not use the word dangerous lightly. He has been the Chief Justice since 2005. He has presided over the court through enormously contentious periods. He has navigated the court's institutional standing through decisions that generated intense political controversy from both left and right. He knows exactly what he is doing when he chooses to speak publicly about threats to the judiciary. And when he uses that word, when he says that personally directed hostility, directed at named judges and justices is dangerous, he is acknowledging a specific and documented reality. The reality that personal attacks on judges by public figures with large followings generate threats against those judges. Documented, specific threats that require security responses, that change the daily lives of the people being attacked, that have in some cases resulted in actual violence or attempted violence. The federal judiciary's own threat tracking data shows that threats against judges increase significantly when high-profile public figures attack them by name and question their integrity and motives. Roberts knows that data. He has access to the security reports. And when he says the attacks are dangerous, he is not speaking metaphorically. He is speaking about actual physical danger to actual human beings who serve the judiciary. Now, let us talk about Justice Neil Gorsuch, because his response adds a dimension that is uniquely powerful given his specific history. Neil Gorsuch was Trump's first Supreme Court appointment. Trump nominated him. The Senate confirmed him. He is, in many respects, the most direct beneficiary of Trump's electoral victory in 2016 in terms of career advancement. Yet, when asked directly about Trump's suggestion that justices owe loyalty to the president who appointed them, Gorsuch's response was clear and unambiguous. He said his loyalty is to the Constitution and the laws of the United States. And he added, it is really just that simple. 4 words that carry an enormous amount of weight. It is really just that simple. That is Gorsuch, Trump's own appointee, publicly rejecting the premise that presidential appointment creates a loyalty obligation, publicly asserting that his judicial independence is genuine and not contingent on the political preferences of the person who nominated him, and publicly doing so in an interview format where his words would be directly quoted and distributed to a national audience. That is a Trump appointee pushing back on Trump in public on the core question of judicial loyalty and independence. And the clarity and directness of his response, it is really just that simple, makes it impossible to dismiss as ambiguous or hedged. He is not equivocating. He is not leaving room for interpretation. He is stating a constitutional principle in the most direct language possible. The significance of Gorsuch's statement cannot be overstated. When a Trump appointee publicly states that his loyalty is to the Constitution rather than to the president who appointed him, it is not a liberal critic making a political argument. It is the beneficiary of a presidential appointment asserting the principle of judicial independence that the appointment process is supposed to serve. Gorsuch's response directly rejects the transactional conception of judicial loyalty that Trump's attacks imply. Trump's framing suggests that justices appointed by a president should rule in ways that serve that president's interests, and that ruling against those interests constitutes disloyalty. Gorsuch's response says explicitly that this conception is wrong, that judicial appointment does not create political obligation, that the loyalty of a justice runs to the Constitution and the law, and not to the political preferences of the appointing president. That statement from that justice at this moment is one of the most important public assertions of judicial independence in recent American legal history. Now let us talk about Justice Ketanji Brown Jackson and why her contribution to this public pushback is significant in a different way from Roberts and Gorsuch. Jackson was appointed by President Biden. She joined the court representing a very different political and jurisprudential perspective from the conservative majority. And she has been one of the most publicly vocal justices about the specific threat she believes Trump world attacks on the judiciary represent. Jackson's characterization of the attacks goes beyond saying they are wrong or inappropriate. She has argued that they are not random, that they are seemingly intended to intimidate the judiciary. That is a specific and serious allegation. Intimidation of judges is not just bad rhetoric. It is a specific form of conduct that strikes at the core of what judicial independence is supposed to protect. A judge who makes decisions under the fear of presidential attack or under the fear of physical threat generated by presidential attack is not an independent judge. Jackson's argument that the pattern and targeting of the attacks suggests intentional intimidation rather than accidental excess is a claim about the purpose and effect of what Trump is doing that goes well beyond normal political criticism of court decisions. She has also said explicitly that these attacks threaten democracy and the rule of law. Not just the specific judges being attacked, not just the specific decisions being challenged, but the foundational institutional arrangement on which democratic governance depends. That is a profound statement from a sitting Supreme Court justice. and it deserves to be taken seriously. The fact that we now have multiple justices speaking publicly through speeches and interviews about the threat that presidential attacks represent is itself a significant institutional development. It suggests that the traditional posture of silent institutional dignity, writing opinions and letting them speak for themselves, has been judged insufficient as a response to the specific and sustained pattern of attacks that Trump has mounted. The justices who are speaking out have concluded that staying silent while the president publicly calls them fools and lapdogs and accuses them of foreign influence would itself be damaging to the court's institutional standing, because silence in the face of those attacks might be read as acceptance. And so they are speaking. Carefully, in Roberts' case, through the frame of principles rather than specific political actors. More directly, in Gorsuch's case, stating clearly that loyalty runs to the Constitution, not the appointing president. Most directly, in Jackson's case, naming intimidation as the apparent purpose. All three approaches are extraordinary by historical standards, and all three reflect a judicial institution that has concluded that the attacks have crossed a line that requires a public institutional response. The justices who are pushing back understand that what they are doing is unusual. They understand that they are breaking with historical norms, but they have concluded that the circumstances require it. And their willingness to break those norms tells you something important about how serious they believe the threat to be. Let us also think about what it means that three justices spanning the political spectrum of the court are making versions of the same argument. Roberts, appointed by Bush, a moderate conservative institutionalist who has spent his career as Chief Justice trying to protect the court's standing as an institution above partisan politics. Gorsuch, Trump's own first appointee, a committed constitutional originalist whose judicial philosophy has generally aligned with conservative outcomes. Jackson, Biden's appointee, a progressive jurist who brings a different perspective to almost every major constitutional question. The fact that all three are publicly raising concerns about the attacks through different forums and with different framings, but all converging on the point that the attacks are dangerous and unacceptable, tells you something important about the nature of the threat they are perceiving. When justices who disagree about almost everything constitutional agree that a specific pattern of behavior threatens the institution they all serve, that convergence is meaningful. It suggests that what is happening is not a partisan dispute about who wins specific cases, but a genuine institutional threat that transcends the political divides within the court. This is not about liberals versus conservatives. This is about the judiciary versus a president who is attacking its legitimacy. And the justices, regardless of their ideological commitments, are united in their concern about where this is heading. Now, let us talk about Trump's response to the pushback, because his reaction to the justices speaking out tells you something important about his understanding of and relationship with judicial independence. After Roberts' speech and Gorsuch's interview and Jackson's public statements, Trump did not moderate his attacks on the court. He escalated them. He continued to call justices who ruled against him on tariffs a disgrace. He continued to characterize the ruling as driven by foreign interests. He said he was ashamed of the justices he had appointed who joined the majority. And he continued to frame the judicial pushback against his attacks as evidence of bias, as if justices defending judicial independence from presidential attack is itself a form of political opposition, rather than the exercise of their constitutional function. That response, escalation rather than moderation in the face of genuine institutional pushback, fits the pattern of behavior we have documented throughout Trump's relationship with the judiciary. Courts find him in contempt 10 times. He attacks the judge louder. The Supreme Court strikes down his tariffs. He calls the justices fools and lapdogs. The Chief Justice says the attacks are dangerous and have to stop. He continues attacking. At each step, the institutional response is to assert limits and principles. At each step, Trump's response is to push harder rather than to acknowledge those limits. And the question hanging over all of it is, What happens when pushing harder eventually runs into institutional consequences that cannot be ignored or absorbed? What happens when the attacks cross a line that Congress can no longer ignore? What happens when the justices, acting collectively, decide that the pattern of behavior requires a more formal institutional response? These are open questions, and the answers will determine the future of the relationship between the executive and judicial branches for generations to come. The confrontation between Trump and the Supreme Court is ultimately a test of whether the American constitutional order is going to hold. The court is one of the three co-equal branches of government. Its authority, the ability to issue rulings that the other branches respect and comply with, does not rest on physical force. It rests on institutional legitimacy, on the shared understanding that when the court speaks on questions of constitutional and statutory law, its word is final and binding, regardless of how powerful the parties on the losing side of the ruling are. When a president publicly calls justices who rule against him fools and lapdogs and disloyal and accuses them of foreign influence, and then continues to use the powers of his office in ways that the court has found unlawful, he is attacking the foundation of that institutional legitimacy. He is saying implicitly that the court's rulings are not the final word, but merely one input in a political calculation that he retains the authority to reject or ignore. Roberts and Gorsuch and Jackson are pushing back against exactly that implication. They are asserting in their own voices that the court's authority is real and its independence is genuine. The attacks on it are dangerous, not just to the individual justices being attacked, but to the constitutional order that the court represents. Whether that assertion holds, whether the institutional legitimacy of the court survives this confrontation intact, depends on factors beyond any individual speech or interview. It depends on whether Congress acts to protect judicial independence. It depends on whether the political community responds to the attacks with condemnation rather than encouragement. And it depends ultimately on whether the American public continues to recognize the court as a legitimate institution whose rulings deserve compliance. We are watching that test in real time. And the outcome is genuinely uncertain. Let us also think about what the attacks mean for the daily lives and safety of the people being targeted. Because the institutional and constitutional dimensions of this story are enormously important, but they can obscure the very human reality that the people Trump is attacking by name, calling them fools and lapdogs and disloyal and influenced by foreign interests, are real human beings who face real consequences from those attacks. Federal judges and justices are already among the most systematically threatened public officials in the country. The federal judiciary tracks threats against judges, and the numbers are alarming. Threats have increased dramatically over the past decade, as political rhetoric has become more heated and as social media has made it easier to direct large audiences against specific individuals. When the President of the United States calls named justices fools and says he is ashamed of them and questions their loyalty and their integrity on a platform with tens of millions of followers, some percentage of those followers will conclude that aggressive action against those justices is justified or even righteous. That is the specific mechanism by which Roberts' word dangerous applies. Not metaphorically, literally. Named attacks by high-profile public figures generate documented threats against the named individuals. And the judges and justices who are being attacked live with the security consequences of those threats every day. That human reality, the actual physical risk created by the pattern of attack that Roberts identified as dangerous, is the most urgent reason why the justices speaking out matters and why the escalation of those attacks matters. It is not just about constitutional principles and institutional standing. It is about the safety of real people doing an important and difficult public service. Now, let us step back and look at the bigger picture. American constitutional history has several notable episodes of tension between presidents and the Supreme Court. Franklin Roosevelt's famous court-packing threat in 1937, when he proposed adding justices to overcome a court that was striking down his New Deal programs, produced its own kind of institutional confrontation. Nixon's resistance to handing over the White House tapes in 1974, which the court ultimately forced through a unanimous decision in United States v. Nixon, tested the boundary between presidential privilege and judicial authority in ways that shaped the constitutional order for decades. But in both of those historic confrontations, the presidency and the court were fighting over legal and constitutional principles through the formal mechanisms of the legal system: cases, orders, opinions. What is happening now is different. Trump is attacking the court not through legal process, but through social media, public speeches, and media appearances, calling justices fools, lapdogs, and accusing them of foreign influence, questioning their motives and their loyalty in terms that are personal and contemptuous, rather than legally substantive. That is the specific novelty of the current confrontation. And the response from the justices, speaking out through speeches and interviews rather than through opinions, reflects the reality that when an attack comes through informal public channels rather than through legal process, the institutional response also needs to engage those informal channels. Roberts and Gorsuch and Jackson are doing something new because Trump is doing something new. And the precedent that gets established by how this confrontation resolves will shape the court-presidency relationship in ways that will outlast both of them. The justices pushing back is genuinely unprecedented, and it reflects a genuine institutional threat. Supreme Court justices do not typically speak publicly about presidential attacks on the court. They do not give interviews asserting their independence from the person who appointed them. They do not give speeches warning that attacks on named judges are dangerous and have to stop. The fact that all three of these things are now happening from justices spanning the political spectrum of the court reflects a judgment that the attacks have crossed a threshold that requires a public institutional response. That threshold is not about political disagreement over outcomes. Every controversial ruling generates political criticism. The threshold that has been crossed is about personal attacks on named individuals that the Chief Justice himself has identified as dangerous, as creating real physical risk to real people who serve the judiciary. Gorsuch's response is particularly significant because of who he is. When a Trump appointee publicly states that his loyalty is to the Constitution rather than to the president who appointed him, it is not a liberal critic making a political argument. It is the beneficiary of a presidential appointment asserting the principle of judicial independence that the appointment process is supposed to serve. Gorsuch's response directly rejects the transactional conception of judicial loyalty that Trump's attacks imply. Trump's framing suggests that justices appointed by a president should rule in ways that serve that president's interests, and that ruling against those interests constitutes disloyalty. Gorsuch's response says explicitly that this conception is wrong, that judicial appointment does not create political obligation, that the loyalty of a justice runs to the Constitution and the law and not to the political preferences of the appointing president. That statement from that justice at this moment is one of the most important public assertions of judicial independence in recent American legal history. Jackson's intimidation claim is the most serious allegation, and it deserves serious engagement. Jackson's argument that the attacks appear intended to intimidate the judiciary, that they are not random, but seemingly designed to create an environment of fear around judicial decision-making, is the most legally and constitutionally serious of the three responses. Intimidation of judges is not just rude, it is an attack on the constitutional function that the judiciary serves. If judges make decisions based on fear of what a politically powerful actor will do to them if they rule the wrong way, the rule of law is replaced by rule of power. Jackson's argument that the pattern and targeting of Trump's attacks suggest intentional intimidation rather than accidental excess raises questions about whether the conduct crosses lines that go beyond political speech into conduct that is itself constitutionally problematic. Whether that argument is correct as a legal matter is a question that courts would have to address in a specific proceeding. But it is a serious argument that deserves serious engagement rather than dismissal as political partisanship. This confrontation will shape the court's relationship with the executive branch for the remainder of Trump's presidency and beyond. The public pushback from Roberts, Gorsuch, and Jackson has changed something about the dynamic between this Supreme Court and this president. The court has now publicly asserted, through multiple justices speaking in their own voices, that presidential attacks on individual justices are dangerous and unacceptable. Trump has publicly escalated his attacks in response, and the entire country is now watching to see what happens next. Does Trump's continued escalation produce any institutional consequences? Does the court's public assertion of independence change the political environment in ways that affect how Republican members of Congress respond to Trump's attacks on the judiciary? Does documentation of this confrontation in speeches and interviews and public statements change how future courts and future presidents understand the boundaries of acceptable presidential conduct toward the judiciary? All of those questions are genuinely open. All of them will be answered by events that are still unfolding. And all of them make the confrontation between Trump and the justices who are striking back one of the most constitutionally consequential stories of the second term. And one final thought before we close. The confrontation between Trump and the Supreme Court is ultimately a test of whether the American constitutional order is going to hold. The court is one of the three co-equal branches of government. Its authority, the ability to issue rulings that the other branches respect and comply with, does not rest on physical force. It rests on institutional legitimacy, on the shared understanding that when the court speaks on questions of constitutional and statutory law, its word is final and binding, regardless of how powerful the parties on the losing side of the ruling are. When a president publicly calls justices who rule against him fools and lapdogs and disloyal and accuses them of foreign influence and then continues to use the powers of his office in ways that the court has found unlawful, he is attacking the foundation of that institutional legitimacy. He is saying implicitly that the court's rulings are not the final word, but merely one input in a political calculation that he retains the authority to reject or ignore. Roberts and Gorsuch and Jackson are pushing back against exactly that implication. They are asserting in their own voices that the court's authority is real and its independence is genuine. The attacks on it are dangerous, not just to the individual justices being attacked, but to the constitutional order that the court represents. Whether that assertion holds, whether the institutional legitimacy of the court survives this confrontation intact, depends on factors beyond any individual speech or interview. It depends on whether Congress acts to protect judicial independence. It depends on whether the political community responds to the attacks with condemnation rather than encouragement. And it depends ultimately on whether the American public continues to recognize the court as a legitimate institution whose rulings deserve compliance. We are watching that test in real time, and the outcome is genuinely uncertain. This is a moment that will be studied by historians and constitutional scholars for generations, and we are living through it right now.